What is the purpose of a corporation? Well, according to the late Lynn Stout, who was then a distinguished professor of corporate and business law at the Cornell University Law School, the business community reached a broad consensus on 3 points dealing with this question by the end of the 20th century. The first point was that corporations are owned by their shareholders. Second point was that executives and other managers should do whatever the owners/shareholders want them to do. The third point was that what the shareholders want is for them to maximize shareholder value, which is measured as share price. And we're going to call this collection of views the shareholder primacy view. Now, the history of the shareholder primacy view begins with 2 articles. First was Milton Friedman's 1970 New York Times Magazine piece, which was called "The Social Responsibility of Businesses to Increase Its Profits." And the second was a 1976 article by Michael Jensen and William Meckling, which was titled "The Theory of the Firm." Now, both articles are important to read, and you should definitely read them at some point in your life if you want to become a serious student of business history. Now, in this video, I'm going to be talking about the legal arguments for the shareholder primacy view. And in the next video, I'm going to be talking about the economic and moral arguments for it. I should warn you, though, that since this is an introductory video, I can't discuss everything. And in particular, I'll just flag that I won't have time to discuss the Revlon Incorporated versus McAndrews and Forbes Holdings Incorporated case from 1986, or the complexities of the status of shareholders as residual claimants. But I'm confident that neither of those topics is going to challenge the claims that I make in this video, but I'd recommend that you go and check them out for yourself. So the first part of the shareholder value primacy view is the claim that corporations are owned by their shareholders. And according to Professor Stout, this reflects an incorrect understanding of corporate law. According to Stout, shareholders do not and indeed cannot own corporations because corporations are legal persons that own themselves. Stout puts it better than me, so I can just quote her. She goes, "Although laymen sometimes have difficulty understanding this point, corporations are legal entities that own themselves, just as human entities own themselves. What shareholders own are shares, a type of contract between the shareholder and the legal entity that gives shareholders limited legal rights. And in this regard, shareholders stand on equal footing with the corporation's bondholders, suppliers, and employees, all of whom also enter into contracts with the firm that give them limited legal rights." Now, the belief that corporations are owned by shareholders is so pervasive that it's even found in the edition of the business ethics textbook that I've assigned for this class. But textbook selection, like many things in life, is often about making trade-offs between imperfect options. And if you wait for perfection in either domain, you're going to die before you're done waiting. Now, a second argument for the shareholder primacy view says that corporate executives are the agents of shareholders, and that therefore corporate executives must do what they are directed to do, which in this case involves maximizing shareholder value. Now, we find something like this argument expressed in Milton Friedman's famous piece that I mentioned above, and I'm going to quote, "In his capacity as a corporate executive, the manager is the agent of the individuals who own the corporation or establish the eleemosynary institution, and his primary responsibility is to them." In other words, Friedman is saying that a corporate executive is the agent of the owners of the corporation, and that therefore the executive's primary responsibility is to them. Now, we've already seen why the ownership claim is mistaken, but Stout denies the claim that the executives are agents of the shareholders as well. In the law, a principal is someone who has the right to control the behavior of an agent. Shareholders, on the other hand, do not have the legal right to control the behavior of the executives of the firm for which they own shares. Instead, their rights are extremely limited. They can vote for who sits on the board of directors of a firm, and they can sue when fiduciary duties are breached. Now, you might think that the ability to sue for breaches of fiduciary duty gives shareholders significant leverage, but this is not the case. Due to something called the business judgment rule, the only sorts of cases where shareholders are likely to collect damages are cases where directors are literally stealing from the firm. The business judgment rule is a doctrine in corporate law that says that courts will defer to the business judgment of corporate executives. So to put it another way, corporate executives are protected from liability from frivolous lawsuits by the assumption that they are acting on good faith to protect the interests of their company unless there is clear evidence otherwise. Now, I'm going to quote Professor Stout again because she always puts these things so well. She goes, shareholders are only likely to recover damages from directors in lawsuits involving breaches of duties of loyalty, meaning the directors were essentially stealing from the firm. So let's consider one final reason why people sometimes believe that corporate executives have a legal obligation to maximize financial value for shareholders. In the year 1919, the Michigan Supreme Court published their decision in a case called Dodge v. Ford. Now, in Dodge v. Ford, Henry Ford was sued by John and Horace Dodge, and they were two brothers who were minority investors in the Ford Motor Company. The brothers were unhappy that Ford was choosing to use the company's enormous profits to lower the cost of cars and increase wages rather than to pay the dividends to shareholders that they wanted. Now, the Michigan Supreme Court found in favor of the Dodge brothers and issued a statement that is now famous in business ethics and business law. And I'm going to read the statement. There should be no confusion. A business corporation is organized and carried on primarily for the profit of the stockholders. The powers of the directors are to be employed for that end. The discretion of the directors is to be exercised in the choice of means to attain that end and does not extend to other purposes. Now, one might think that this is a decision that provides a straightforward legal case for the shareholder primacy view. But here's the thing. The interpretation of this case is controversial. And so rather than taking a side in the controversy, I'm going to give you two interpretations of the decision and then draw conclusions that are consistent with both interpretations. So, on the one hand, Professor Stout thinks that Dodge v. Ford is bad law. And I'm going to summarize her reasons. So first, it's over 100 years old at this point. Second, it was decided by the Michigan Supreme Court, which was not anywhere near as sophisticated when it came to corporate law as the courts of Delaware, New York, California, or Massachusetts. Third, the excerpt quoted above was mere dicta that was irrelevant to the reasons why the court sided with the Dodge brothers. Now, this third point is kind of complicated, so we're going to break it down a little bit. According to Stout, Professor Stout, the reason why the court sided with the Dodge brothers was because Ford, the controlling stakeholder of the Ford Motor Company, was violating his fiduciary duty to engage in good faith with the Dodge brothers, who were minority stakeholders. Now, at the time, Ford wanted to deprive the Dodge brothers of the money that they needed to set up a new car company, and he wanted to lower the share price of the Ford Motor Company so that he could buy the shares from the Dodge brothers at the lowest possible price. Now, a good way to accomplish both ends was to not pay dividends to shareholders. So according to Stout, we should understand the decision in Dodge v. Ford as a decision about the duties between controlling and minority shareholders rather than a duty between corporate executives and shareholders. Now, back in 2008, when Stott was writing about Dodge v. Ford, the only Delaware opinion that had cited Dodge v. Ford in 30 years cited it in the context of a conflict between controlling and minority shareholders, rather than corporate executives and shareholders. Finally, Stout points out that when we look deeper into Dodge v. Ford decision, we also see a respect for corporate executives, quote, implied powers to carry on with humanitarian motives, such charitable works as are incidental to the main business of the corporation. So in other words, the Dodge v. Ford decision itself indicates that corporate executives can engage in charitable works. So the shareholder primacy view isn't as well supported by the decision as one might think simply by reading the famous quotation that I went through above. So on the one hand, that's Stout's view. On the other hand, Jonathan R. Macy, the Sam Harris Professor of Corporate Law, Corporate Finance, and Securities Law at Yale Law School, strongly disagrees with Stout's interpretation of Dodge v. Ford. He argues that Dodge v. Ford correctly describes the purpose of a corporation and cites Section 2.01 of the American Law Institute's Principles of Corporate Governance, which states, and I quote, a corporation should have as its objective the conduct of business activities with a view to enhancing corporate profit and shareholder gain. Nevertheless, as Macy points out, the principles also state the following, and here I quote again. Corporations can ignore shareholder wealth maximization in order to, 1, comply with the law, 2, make charitable contributions, and 3, devote a, quote, reasonable amount of resources to public welfare, humanitarian, educational, and philanthropic purposes. So, and I quote, in other words, the only exceptions permitted by the shareholder wealth maximization norm are those necessary to ensure corporations be given sufficient latitude to act like responsible community members by complying with the law and supporting charities and other worthy causes. So that's the end of the quote by Macy. Now, on Macy's interpretation, the decision in Dodge v. Ford correctly notes that the primary purpose of a corporation is to make money for shareholders, but corporate executives also have leeway to support other causes in the ways just described. So, if corporate executives are allowed to direct funds to socially responsible causes rather than paying dividends to shareholders, then why did Ford get in trouble for lowering the cost of cars and increasing wages rather than paying dividends? Now, according to Professor Macy, the reason why the court decided in favor of the Dodge brothers was not because Ford used money to lower prices and increase wages rather than paying dividends. Instead, it's because the justification Ford offers for his decision. So Macy thinks that Ford would have won the case if he had said that his decision to direct money towards wages and the cost of cars was to increase market share and develop a better labor force that would, in the long run, benefit the corporation instead. What Ford did instead was boldly proclaim that he had no obligation whatsoever to benefit shareholders. So it's not what Ford did that lost him the case. It's why he said he did it. That was the problem. So that's Macy's interpretation. Here's the upshot. Whether you agree with Stout or you agree with Macy, corporate executives aren't violating legal obligations when they direct money from the firm towards socially responsible ends, rather than seeking to maximize short-term share price. According to Macy, however, there is a catch. It's a bad idea for an executive to do what Ford did, to explicitly state that he has no obligation whatsoever to create value for shareholders. So, all right, that was a long trip into the weeds of a Michigan Supreme Court decision from the early 20th century, but I needed to do it, so I thank you for coming along with me for the ride. At the end of the day, it's safe to conclude that the shareholder primacy view, as I characterized it above, is not a legal requirement. Even if you think that the primary purpose of a corporation is to make money for shareholders, corporate executives will not get in legal trouble for directing money to pro-social ends as long as they believe, or at least are willing to state in court, that doing so is in the best interest of the firm.